Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the legal dictation without any stop. The petitioner having been selected as a constable for being appointed in the Uttar Pradesh Police Services was subjected to police verification. His verification report was received to the effect that the petitioner was involved in a criminal case prior to his selection and therefore such involvement does not entitle him to seek employment in the police services. Accordingly, his candidature was cancelled. The petitioner made a representation which was not being considered, as a result whereof he filed writ petition number 69759 of 2006, which was disposed of on 20th December 2006 to examine the claim of the petitioner and pass an appropriate order. In compliance of the aforesaid direction, the impugned order dated 5th January 2007 was passed on the ground that the petitioner was involved in a criminal case and therefore such involvement does not entitle him for employment in the police services. After passing of the said order, the petitioner was honorably acquitted by the Criminal Court in case crime number 616 of 2006, and the decision was rendered by the trial court on 29th January 2007. It is therefore clear that the said judgment was not before the Senior Superintendent of Police when he passed the order dated 5th January 2007. The petitioner has approached this court questioning the correctness of the impugned order and has brought on record the order of acquittal through a supplementary affidavit. This court, after examining the said acquittal order dated 29th January 2007, passed an interim order on 28 to 2007 staying the operation of the order dated 5th January 2007 till the next date of listing. A counter affidavit has been filed on behalf of the state and the same position has been taken, namely that the petitioner, being involved in a criminal case, was not entitled for being selected and appointed. Learned counsel for the petitioner submits that the acquittal of the petitioner entities oblig entitles him for employment. It is submitted that the impact of the acquittal order is that the petitioner was never involved in any criminal case, and even otherwise, the petitioner had filed an affidavit before the authorities disclosing his involvement. He submits that this honest disclosure was in accordance with rules and keeping in view the subsequent acquittal. The claim of the petitioner deserves to be reconsidered in the light of the same. Learned standing counsel, on the other hand, contends that the petitioner had an antecedent of being involved in a criminal case and therefore it cannot be said that the impugned order is erroneous. He further submits that the order was passed on the basis of the material that was available, and in the absence of the order of acquittal, it cannot be said that the order suffers from any infirmity. Having heard learned counsel for the parties, the contention of the learned standing counsel to the effect that the order of acquittal was not in existence when the impugned order was passed appears to be correct.